Happy Cinco de Mayo! Welcome to Chip at 2 o'clock. Who says property insurance law can't be fun?
Not me.
Not you. There
So
you
much
go.
fun.
You better not say it can't be fun. So we're here today to have some fun, to go through some questions, and somebody reminded me of Cinco de Mayo, and I'm Chip Merlin. We're going through that. That's Larry Bache. That's what he looks like when he's not dressed up for Cinco de Mayo. I got to put those down now. You can go crazy if you aren't used to using them, but I guess I don't know what the sound is like that. But here we go.
Hold on. Before we get started, please open the PowerPoint presentation. Megan and Justin are going to put up on the link in the comment section. So as we get started, please open the PowerPoint presentation because today is a very special week because we're answering the questions from the previous 2 or 3 weeks. We put them all in one presentation. So please go back in time and download the other presentations with the materials that are hyperlinked so that you can have that information.
And if you think of something today, you can sit down there and write a question like everybody else does, because we get all these questions that they go through. And then when Larry doesn't know what the answer is, I'll give it to you. Okay? Yes. So I know we have a number of questions, that were from last week. I think I posted one on the blog from yesterday. Actually, that's not the one. The very first numbers. Is it legal for independent adjusters to represent policyholders? That's not really, I'm going to tell you a different question. So I got a question posed to me because somebody was afraid to write the question during the session. Can you imagine somebody being afraid? Look, if we're not afraid, you shouldn't be afraid.
If I'm not afraid to wear this hat forever, you should not be afraid to ask a question.
You look great, Larry.
Yeah, please.
You should be in, I wouldn't say Mexico City. Could you imagine if he was down in Tijuana right now? They're probably having a lot of fun.
Yeah.
Anyway, the question that was posed to me had to do about appraisal, and the question said something to the effect, geez, Chip, if I'm an appraiser, do I have to go out and get permission from the insured regarding the number that I've come up with to present to the insurance company's appraiser? You know what? You're the appraiser. You don't have to get permission to go come up to what your opinion of what the value is. As a matter of fact, a lot of times, because I represent policyholders, I think what's going on is that the insurance company's appraiser, after coming up with that person's own independent valuation, goes back to the insurance company, and then they tell them you can't go above this amount. I don't think that's right. And I definitely don't think it's right that then the policyholder who has already appointed you tells you what that number ought to be. That would not be right. As a matter of fact, what you should do as an appraiser for the policyholder once they appoint you is to find out all the information that the policyholder might have regarding the loss. Who else might know about the loss? If there's a public adjuster involved, what kind of estimates were made? What kind of construction estimates? Get as much information as you can so that you can come up with your own independent valuation of what the insured loss is. Period. That's what you're supposed to be doing. As a matter of fact, you should be getting the insurance company's information and the best you can before you come up with that if you're the policyholder's appraiser. So you can come up with an opinion that's based upon something and all the evidence that would be available for it. I always tell people, if you want to get a good appraiser, pick one that's going to work hard, look for all the information, and come up with an honest result. You don't, and please don't, feel like you have to go back and, because it would be wrong for you to go back and say, well, I can only say what the policyholder told me to say. That's not the purpose of the appraisal.
Right, and it's just as wrong if you're a carrier appraiser and you feel that you're being constrained by the insurance carrier's position. I mean, at the end of the day, you are there to provide your independent evaluation that's supposed to be unbiased. And so it's wrong for both parties to rely or get permission to agree to an amount of loss, and that would be inappropriate. Slide 6 is our next slide. And the question, Chip, is it legal for independent adjusters to represent policyholders?
Well, no. It would be illegal, especially in the states where they're licensed to be. Now, if the independent adjuster is licensed in one state, suppose they're licensed in Georgia as an independent adjuster, but in Texas, they're licensed as a public adjuster. And in Texas, that's where the policyholder is, and they haven't had any work on that particular file as the independent in Texas, they could legally represent a policyholder as the licensed public adjuster in Texas. And somebody asked me the question, well, geez, Chip, what about in states?
What about Georgia, though? In that situation, he has no PA license in Georgia, but he is an independent adjuster. Can
No.
he represent policyholders in Georgia?
No, you would be violating the Georgia law. Only public adjusters can represent policyholders. And in there, he's only supposed to be appointed by insurance companies to do the adjustment of a claim on behalf of insurance companies. And you have to go back, I know some people switch back and forth. You have to look at the licensing for a state for, how long you might have to wait before you do it. Some states it's right away. Some only let you make the switch once a year. There's all kinds of things like that. And I often tell people, shout out to Holly Soffer. If you want to know all that stuff, you can call Holly Soffer. Another big shout out to the National Association of Public Insurance Adjusters. They got a whole chart typically about public adjusting licensing all over the place, and Brian Goodman puts that together for the National Association of Public Insurance Adjusters.
All right, so the answer is, if you don't have a PA license, no, you cannot represent a policyholder, even if you have an independent adjuster's license in a different state. Next question, which is a lot from last week, if you go to slide 7, Chip. Can you talk on properly vetting umpires?
So we did. I talked about it for about 30 minutes, and then Larry, we were supposed to be done, talked about another 30 minutes. We did a whole hour of talking about the vetting of umpires. So if you go back to what we all did last week, you'll find out what we talked about that. I think the bottom line is both sides are looking for any number of various criteria for looking at that. But we have whole slides and stuff like that. If you go back to last week's presentation, and
I think the key takeaway was there's a list of questions that were accumulated from last week that we included in a slide.
So the answer is yes, we can.
We did.
Yeah, we did.
All right, next question, Chip. Slide number 8. If you'll go to slide number 8. And Megan. And again, this PowerPoint presentation is posted in the comments section, so take a second to download that. All right, question. What should happen when both appraisers meet on site to appraise the loss? So Chip Merlin, tell us how the appraisal process with no formality rules is supposed to operate.
Well, you can make up the rules as you go if you want to, because there's actually no set rule, no formal rule you have to go do. I know you can go and here I'm going to give some other stuff. You can go to the Windstorm Insurance Network at the Windstorm conferences, and even I think they have mid-year stuff doing that, especially John Doan and John Vopel. They really got a great program for the Windstorm conference with their certifications that tell appraisers what to do. The guys at the IAUA, and I think that's Jonathan Wilkowski and Bob Norton and their crew. They've got all kinds of stuff, out there for teaching appraisers what to do. I got a feeling that I think Steve Patrick, probably with his group, goes through some of the teaching. I'll give a shout out. I didn't to Cal Spoon. I think Cal and some of his adjuster trainings got some of the stuff about what to do about appraisals and how to do that. But I would suggest this, guys, just from a practical standpoint, before you go out, two people get appointed. Since you're supposed to be appraising the differences, why don't you see if you have any differences before you go out to the loss site? It might be you agree. It might be agree on 95% of the stuff, and it has something to do. You don't need to go out to the loss site. So for me, at least, the first step before going out to the loss site to meet out there to appraise the loss, if y'all have independently done this already, you might be able to cut out some expense to the policyholder and to the insurance company, and see what you come to agreement with first. And that would be my first suggestion. But what Larry, what should happen when both appraisers meet on site to appraise the loss?
Well, I think the first question is, are appraisers even required to meet on site? And the answer is no, they're not. There is no formal requirements in the policy that they actually meet at the property. I've heard about appraisals. We often do arbitrations and jury trials, and we're not able to take the jury to the trial. We have to use photographs. So a lot of times I get the question of, hey, the umpire doesn't want to go to the property, but the other appraiser will not meet me at the property. There is no requirement.
The property could have been completely destroyed.
Or the property is destroyed. So I think that the way it should happen is there's a lot of common sense. If you take any of these courses or training, you should narrow down what your differences are. You should go to the property. I think in most cases, you should be able to identify, because a lot of times you're going to have consequential damages that the carriers are not paying for, because more and more you're seeing this direct physical damage or loss language being narrowed, where they're not including some basic insurance principles like consequential loss or reasonable uniform appearance. So it's always best to go to put your eyes on the site with the opposing appraiser and obviously the umpire. But surprisingly, it's not required. So I think that's the way it should be done. Anything else you want to add before we move on to the next exciting question?
Well, I think the reason why a lot of people go out there to do it is the same way you would be doing it for the adjustment of a claim anyway. A lot of times if people get out to the law site and they're going through their differences with respect to the scope of the damages, it's not just to see where the damages are, but talk about the methodology of construction, how things are going to have to happen, what those
Access,
costs are.
not just access,
And so being
but
able to
to-
walk around and say, oh, okay, I see what you're talking about, these various considerations that somebody else might not, have done. If let's face it, if Chip Merlin's telling his policyholder appraisers go work, and make sure you spend enough time to know the ins and outs of how to do the construction and all that, I would expect that the appraiser for the policyholder should be able to go out there and point out exactly what they're doing, why they're doing it, and see if they can come to some agreement with it right there on the spot. So,
Yeah, one more practical point before we get to the next question. Number one, with all appraisals, I think the proper thing to do when you have multiple buildings is make sure you're talking about the same buildings. A lot of times, it sounds funny,
it's true.
but if you have an HOA claim and you've got 45 buildings, 60 buildings, 130 buildings, it's odd how the carrier will identify them as letters or numbers, but they're different orders. And so the first step I would take as an appraiser when you have multi-buildings to the claim is make sure you're talking apples to apples, because if you don't get off on the right step to begin with, you're always playing catch up on what building are you referring to. Is it my building 2 or your building 2? Or is it State Farm's building 5? Or is it my building 7? So that'd be my last practical point. The next question, the next slide is one that I am going to talk about. The question is there a problem with a contractor paying for the appraisal cost with an AOB or AOC, which is an assignment of benefits or assignment of claims? The answer is yes and no. There's a problem with it if it's something that's built in for the claim, because the deductible has to be paid for by the policyholder. And appraisal costs are typically not covered. There are some policies, it's rare, where they've got professional fees that are covered, but that's becoming less and less apparent. So majority of the position is no, it cannot be paid for those appraiser costs. However, with the assignment of benefits and the assignment of claim, there's an argument that if they cover it from an administrative standpoint, where it's not related to the claim and they collect 100% of the deductible from the policyholder, I believe there's an argument to be made that that's the right way to do it, but it better be 100% legit. So better safe than sorry. I would not count on paying the appraiser cost out of the deductible if you have an AOB or AOC. Fair enough?
Man, I wonder what happened. Somebody checked in late and they're wondering why Larry Bation's got this big old colorful hat, and they might need a reminder. It's Cinco de Mayo! All right, let's keep on going.
I feel like I'm on the Dan Lapitard show. All right. Okay, Poppy.
Let's go.
All right, next question. What happens? Here's a good question. All right, Chip, you ready for this one?
I'm ready for this one.
Next slide in the PowerPoint. What happens if the umpire lies? He's a liar, Chip. During the questioning process, the initial questioning process, and it's not found out until after the award is issued.
Maybe his pants go on fire?
Ooh.
I don't know. I mean, so that's an open-ended question. I mean, it depends on what he's lying about first. I mean, if they asked him a question and it was just an embarrassing type thing, but it's not material at all, it just doesn't matter. So now if he lies about something like, geez, are you taking money under the table from the other guy, and
It really
you say
goes to
no,
that. I mean, it goes to the
you know.
question of, can you get an award set aside? And generally speaking, it's very difficult to get an appraisal award set aside, because the courts love the fact that there's an alternative dispute resolution process that takes the case off of their docket and takes it away. And that's why courts really like arbitration and appraisal, because they don't have to deal with it. They've got plenty of cases to work on, and they just don't like to deal with it. So because of that general premise, it's hard to get the award set aside. Most law around the country is you can get an award set aside for limited circumstances. One of those limited circumstances is obviously fraud. So if you're able to prove fraud, because if they're lying about something fraudulent, then yes. If they're lying about something about impartiality.
So give everybody an example about what might be
Sure.
fraudulent for the umpire.
So if you're an umpire and you've misrepresented disclosures, because of course you're going to ask for disclosures. Have you worked with this appraiser before? Doesn't mean he's an impartial umpire, but he has to be honest. Have you worked for this insurance company before? And we find out later that he misrepresented. Well, I would argue that misrepresentation would lead to the award getting set aside, because it goes to his impartiality. And one of the requirements for the umpire is that they're impartial.
Well, but it's still got to be material. So if you worked for them before, it's been 5 years ago, and you gave the wrong answer, and
Yeah.
it came out that you're actually, and maybe the person should be an arch enemy of them anyway.
Right.
You know, so
But if
All
I
these-
misrepresent that I'm getting $200,000 a year of umpire work from an insurance carrier, and I'm asked that specific question, then obviously I believe as an advocate I can get that award set aside. But if you're talking
yeah,
about
but you don't, but you can't get it. It's half and half, right? In other words, if the person's been an umpire before, it's not just on the insurance company's claim; it's also with the policyholder. So, are you suggesting that an umpire who might do 5 cases a year on State Farm cases should not be qualified to be an umpire?
No, I'm suggesting that he disclose it properly if he's asked. And then
Okay.
that misrepresentation would be the problem. If he discloses it, I'm not suggesting, we work a lot with umpires and appraisers, and we believe that their credibility, just because they work with us, does not mean that somehow they're unethical, right? I mean, that's
Right.
kind of the insinuation of if you have a contingency contract as a public adjuster or plaintiff lawyer, we all know that there's not one claim in the world that's worth our licenses. And so it's ridiculous to just presume, which I've heard these arguments, that if they work with them in the past, there's got to be a bias, or if you go to a conference and you get an award, or there's a relationship. That's all ridiculous. I'm not suggesting that just because there's a pre-existing relationship is fraudulent, but I am suggesting that if there's a specific disclosure request, and some jurisdictions like Colorado require certain disclosures, that those disclosures have to be met, otherwise you're going to have a problem with upholding that award. Next question.
Next question.
All right, here we go. Can the cost of appraisal and/or PA fee be counted toward the deductible? Similar answer to the AOC, AOB question a moment ago. The answer is no. Unless the appraiser fees are in addition to coverage under the policy, the answer is no. The appraisal fee is separate. It cannot be counted towards the deductible.
The policy says you pay for your appraisal cost and half the umpire cost, but none of that's supposed to go to the deductible. It's the cost of the resolution of the claim.
Same thing with the public adjuster fee. I mean, the appraiser issue is even more obvious because the policy specifically says that. The PA fee is silent on the public adjuster fee most of the time. And no, it cannot be counted towards the deductible. It is a portion of the claim payment, and the deductible has to be paid, guys. It has to be paid by the policyholder. All right, Chip, this is one of my favorite questions because we kind of talked about it last week with this new trend of the insurance companies.
Favorite question.
Yep. It's this idea that you should have a specialty. You should be an engineer to be an umpire. You should be an adjuster to be an umpire. It's one of these ideas that they're trying to get their industry professionals into this process through these court-awarded umpires versus this idea of fairness. Like, what's the most important part about the appraisal process? I believe most people will agree, fairness. And so the question is, do you like retired judges as umpires? You know my obvious position, Chip. What is yours?
I like retired judges. Just for the record, I always like retired judges. I like current judges. I want all the current judges to know I like retired judges too. So that's my answer on that. Obviously, you like judges. Now, sometimes the problem is with judges. I've found sometimes they have no idea what they're doing, and most judges I find to be very, very, very bright, and they're up on things. Unfortunately, some judges have no idea and no clue about what costs are today, and they rely sometimes upon their own biases versus what really is going on in the modern world, and so they tend to be more, I think, conservative that way on some values, but not all judges. And some retired judges are very up on it, and that's all I can say about that. I mean, in Houston, they're almost appointing all retired judges in their system that they've got for you just go up there and appoint the umpire, and it was almost seems all the umpires were retired judges. It's not that way now, but it used to be that way.
So here's an interesting topic, Chip, that I didn't even, flash alert, you didn't hear about this one. But on Friday, I had a mediation with a retired judge in Colorado with JAG. And he told me that their insurance company now, that insures them, is telling them that they're no longer allowed to inspect buildings and inspect roofing systems.
Why not?
They said that it's too much liability. And so now these retired judges start telling me that they can no longer serve as umpires, which is a really disappointing factor because specifically in Colorado, JAG is a
Liability for what?
personal injury and different liabilities like that because of their age of these different retired judges. It's all retired judges. And so he told me on Friday that he can no longer serve as an umpire, and he's one of the best umpires in Colorado. And so it's very unfortunate that they're not able to do that anymore. And I wonder why, their insurance companies tell them they can't serve as umpires anymore.
Well, I don't know which insurance company it might be. They're malpractice carrier?
Yeah, they're not
Because they can't, that's interesting. I have no idea. I guess maybe if you're not, you talk about the competency of an umpire, but if you have to go out and take a look at it, how do you get and climb up and take a look at some of the damage where it's going to be if you can't physically, in some instances, climb a ladder? Or, if you're in a marine vessel, go climb down a ladder, get down to the bottom hole of a ship, where you might sometimes have to, view things. And that's something I guess we all have to worry about as we get older, and I hope I'm not getting there too fast. But
I just hope it's not a trend that the retired judges are no longer able to serve as umpires because of concerns over.
well, it wouldn't be just retired judges. You would think that would be across the board. I mean, I can't imagine, we're gonna go and single out just the retired judges for this. I think they're probably singling out, I don't know who they're singling out right now, because I don't know what the criteria the insurance company use. The only thing I can think of is, as you get too old, you're not able to go around and look at buildings the right way. I have no idea why somebody would get disqualified by their errors and omissions umpire insurance. We'll have to ask some of those guys. John Doe's getting a bit older. Maybe I can go ask him.
All right. So next question is kind of repeat. So we're going to skip the next question and go to the next slide.
Oh, it is.
Okay. Next question.
So what slide are we up to now?
This would be slide.
We're at the one that says, do you have any information to give to potential umpires
13.
so they understand their ethical duties? Well, sure, I can answer that one.
Yeah, last week.
I would suggest go to the Windstorm Insurance Conference for their certification for umpires. They have some ethical considerations right there that are really good. I believe the IAUA has some as well for being an umpire. I didn't take the certification for the umpire because I never wanted to be appointed as an umpire. I was also probably afraid I'd fail the test. For it. It's a tough enough test that they came up with, but the truth of the matter is I think those two ethical duties are spelled out as to what they're supposed to do.
Yeah, and it's all available to you guys. If you go to our Facebook with Live with Chip last week, and there's a bunch of links in the slides, and you'll see all these different articles and different ethical standards that you can download and put in your portfolio. If you ever have a question for an umpire like that, provide that information to them, because you want to make sure you're being transparent. But please do it in a way that's respectful. Don't try to shove it down somebody's throat that you're accusing them of unethics. I had a lawyer recently remind me of my ethical duties. All that did was just made me very unsettled that someone would remind me of my ethical duties.
Somebody had to remind you, Rick. Did you forget them?
No, I didn't forget them. So it's pretty ridiculous. But yeah, anyway, it was kind of it was an interesting strategy to get me off, but it was fun. So the next question is more of a state-specific question, but it really is not. It's kind of over all the states because the appraisal process, this particular question would apply everywhere. It says, in Nevada, if a policyholder demands appraisal on high-end kitchen cabinets and high-end library cabinets, can the carrier demand additional items to appraise even though they agreed to pay?
Does this question make any sense?
I think what they're saying is are they, if we ask for appraisal on 2 items, do we have to appraise all the items in dispute? And I would argue that, yeah, if there's in dispute, if you're trying to resolve the claim, you don't get to pick and choose what portion of the dispute to resolve through the appraisal process.
But I think the parties can agree. Look, that I think the parties can agree. Look, we agree upon everything except for this particular matter. Do you want to go ahead and just appraise these particular items? And the other party in writing says, yes, we will agree just to appraise those because we have agreement on the rest. It certainly would save everybody a lot of money and a lot of angst because you've reduced the amount of the disagreement. But if you read the appraisal language, it says if you and I fail to agree upon the loss, I do believe that means because there's another provision in the policy that also says if we agree upon the loss, we're going to pay you within 30 days. I would imagine the insurance companies, for the undisputed portions of the amount that they agree upon, are paying right away. The only thing left to appraise should be the disputed amount, so it should come out that way. I think sometimes people just tend to forget about that and making payment for the undisputed amounts, and we're going back and looking at the entire amount again on, almost like, hey, you agree with me, on this, or I'm going to come back and we're going to start from square one, which we've definitely argued in some jurisdictions would be bad faith, because why shouldn't an insurance company just agree to pay for the amount that they have no dispute with the policyholder and go to appraisal on the part you have a dispute? Almost makes no sense otherwise. But did you research Nevada law on this?
Oh, yeah.
On high-end cabinets and I guess it depends how high-end they are.
Yeah, nothing unusual about those issues in Nevada compared to anywhere else. I mean, I think the issue is that in that circumstance, the carriers, the way I read this question is there was an agreement on everything except this area, and I don't think you can pick and choose what goes to appraisal, just like I argue the carriers can. We argue all the time that the carriers, when they open the door to coverage, especially in states like Florida and other jurisdictions that has great case law that says unless there's a denial of the claim is ripe for appraisal. But we would never allow a carrier to all of a sudden say, well, we're only going to appraise what we felt was below the deductible or the repair or the harvesting method. We're going to appraise the entire loss, and it's going to include causation, repair methodology, and consequential losses, and even reasonable uniform appearance. I mean, we know based on the case law in Minnesota, with Cedar Bluffs, with Hamlin in Colorado, and other jurisdictions, that those issues are going to be up to the trier of fact, whether it's the appraisal panel or a jury. So I don't want to get too much off topic, but yeah, absolutely, I think it should be included. The next slide is a very interesting question. I relate this to how we try cases at Merlin. I'm interested to hear what Chip's perspective is, but the question is, why is it good for a PA or public adjuster to hire an outside third eye as the appraiser?
For a number of reasons. In most jurisdictions, public adjusters are hired on a contingent basis, not all of them. There's a few examples where you have to get hired on an hourly basis, Louisiana being one, but I think there's a few obvious examples. Number one, an independent person truly is independent or should be independent regarding it. They're going to be taking a view of it afresh, looking at all the evidence. They can accept or reject what the public adjuster did before. They're not being paid on a contingent fee, which is probably the biggest issue and one being fought even in Florida right now. Certainly you can imagine if you're on a contingency fee and it's a big amount of money, how much that might inure to somebody versus just doing on an hourly basis. At the same time, I hear everybody on the smaller, claims a $5,000 claim, how's the policyholder ever get made whole? Who knows on that? But if you're from the quote outside, in which mean outside is completely independent, not part of the prior work done with the policy holder, you aren't trying to perform. You're not trying to perform a contract on behalf of this individual where you made promises for advertising, solicitations. As a matter of fact, what an appraiser is supposed to be soliciting is coming up with a honest opinion about what the full amount of the damage is, and that's what they're supposed to be doing. I know I've made some comments in the past about on either side, people saying, oh, I've kept the amounts down, and some other side saying, hey, look how much more money I've obtained versus really what the honest amount should be. And again, I've been thinking an appraisal, the other side even could come up, look at this guy, he's always talking about how much more money he's getting. He's biased for it that way to an extent.
They take it out of context all the time.
And,
obviously, you want to.
But it could. You're right. It could be. There could be any kind of reasons why somebody got a much higher award than what the insurance company is. We know, but most of that could be. But the truth of the matter, I think most people look at, and it's the reason why the courts do, is having a person that is not on a contingency fee, because the courts require your expert witnesses, to typically not be on a contingency fee, so you don't have an outcome vested in what your opinion is. And I think that's probably the strongest reason for not having that. That's just my take on it. But so I will say this, that some public adjusters that work really, really hard and they really, really know their case, much better than somebody else. They hate to give up that control over their case. And on a smaller amount, we're going to be asking the insurance company to go to the appraisal. I've often said, why don't you, if you really want to be the appraiser, why don't you, and you're in a jurisdiction which would otherwise prohibit it, disclose it and say, I would like to be appointed, and knowing I'm going to be appointed, if you want to, you can appoint whoever you want to appoint on your side, even the current adjuster on it, and we can then take it to the third party umpire to make the change. It'll keep your cost down to my client. We just have a difference of opinion on this. And I've seen people in writing, agree to change the terms and so that it's allowed even in those jurisdictions that otherwise is not. So, you know, every case is a little bit different, you know, on this, and you have to take a look on it with full disclosure. Typically, though, outside, you know, appraisers are the way to go and have to be that way in most jurisdictions except Florida.
Yeah, I think it's also good because sometimes the outside appraiser sometimes has more experience. And they can also identify methods of construction that maybe were not identified through the public adjuster's adjustment. On the flip side, that's where the public adjuster gets frustrated when maybe the appraiser. So obviously vetting the appraisers is important. Going back to your point, at trial, we always want to present a third party opinion that has no contingency interest. And whether it's a jury that's making a decision, a judge, or an umpire, the credibility is going to be important, and that credibility is going to be questioned if there's a contingency. Right, wrong, or indifferent, guys, we understand this is very highly debatable, and we can have this conversation all day, but we're going to move on to the next question.
I guess we don't want to turn it to, I don't know how you say six in Spanish, but seis.
There you go. Okay, next question is, if an appraiser or both of them introduce a very significant element of damage that was not in the pre-appraisal claim handling, what is your recommendation for the panel? Now, to me, this is obvious. To me, if you identify this, notify the insurance company, at the same time you notify the policyholder. And if there's a public adjuster, they will update their scope, present the claim, or the insurance company update their scope, and that is something that needs to be decided before you finish the appraisal process. Because what's going to happen is if you don't do it the proper way, in my experience, they're going to argue that was not subjected to the appraisal because they were not aware of the dispute at the time of the appraisal, okay? So that's why if you find something like that that needs to be adjusted, there's nothing that says you can't do supplemental claim at that point in time that I'm aware of. You submit it, you have the insurance company make a decision on it, and then a good advocate's going to ask the insurance company, do we really not want to just go ahead and take advantage of this appraisal process and include that in there to save costs, or do we really want to adjust this process out and then also maybe have a subsequent appraisal, or maybe stay the appraisal process and incur those additional expenses? That's my approach to it. That's worked in the past. Chip, have you ever had any experience with this?
It happens I think it, you know, it depends on what you call significant element of damage that is not part of the appraisal claim handling. I think it comes up quite a bit. People miss stuff as they go out there, new people take a look.
But it used to not be challenged.
So
now, every chance the carrier gets, I hate
well, that's because the insurance carrier challenges. I think the main thing is for the umpire then to, how do I say this? If the since it's a new element of damage, I typically find that what it is from the policyholder side, because for some reason the insurance company's appraiser rarely finds something that was ever missed. If anything, they find stuff that should not have been in there 90% of the time. Let's just face it, that's just the way, you know, it is for some reason. I would suggest it's probably because appraisers for insurance companies are more inclined to act in favor of the insurance company, and probably appraisers pick for the policyholder, or if instructed properly, are working as hard as they possibly can to find all the damage, you know, and not necessarily everybody to begin with out at the scene is doing it that way. The insurance adjuster is under time frames to get stuff done. Typically he's moving things along. If it's a catastrophe, if you just read a lot of the literature with respect to the insurance company adjustment, they expect at least 20% of the claims to be significantly wrongfully adjusted. It could be high or low and should be, you know, that way, but if doing it, but they're going to miss stuff that's out there. And if all of a sudden people who are first out there looking at it are missing something, it's much more important to get it right than, you know, everybody, oh, we got something new. No, it might come up. The main thing then for the umpire is to make certain that both sides have a chance to vet it. I mean, both sides, both appraisers have a fair chance to vet it, you know, take a look at it, you know, explain it and stuff like that. Typically, they don't have that chance to do, and it's done. The umpire said, well, you had your chance to look at everything. I'm sorry, you just missed it, and I'm going to go with him, and that's the end of it. And the other guy's completely surprised. I think that's where people might have a hard time, or an insurance company swallowing the fact that, what is this? We got surprised about this. This is not something even in contemplation because it's higher than the scope of the damage that came back before. So again, a lot of that can be stopped though by exchange of information and oftentimes so that people don't feel like it's an improper or unfair procedure. But I think it comes up all the time, and off they go rather than have two appraisals. I mean, we gotta get this, it's supposed to be fast and quick and moving
Right.
along.
So Stephen Vanook asked a good question. There's not really great answers. It says, what if you can't get the carrier's appraiser to inspect for 6 weeks? And I think this is a common problem that we have. I'm dealing with it right now, especially with COVID-19, where we've even entered into agreements with deadlines. Something that I often do, Chip, is when I have a claim that's going to go to appraisal and there's already a lawyer involved on the other side, we may agree to a timeline. And it's more than a suggested timeline, but it's obviously not binding timeline. So the goal is to make it efficient and get it settled. And the way that we do that is we say, listen, we're going to need a tolling agreement if this doesn't get resolved, which costs money and time for the insurance carrier, and they typically will agree. So try to get a timeline of expectations up front. Obviously, it's very frustrating when these appraisers take this long to do an inspection. They take this long to make a decision. And it's really frustrating for all of us that represent policyholders because they're the ones calling us. Hey, when is this going to be finished? What can you do to push this along? It's difficult. I think the best thing you can do is just document the correspondence, copy your client on that correspondence, and then reach out to the carrier if there's a problem, or have them reach out to the carrier and say, listen, can you contact this appraiser and make this a priority? I've also done that, and it's been very effective, but it is frustrating.
And I've seen it, I've been around long enough, I've seen it both ways. I get very frustrated when there has not been a question posed by the insurance carrier or even posed by a client to the client's to the policyholder's appraiser. Do you have enough time to do this? Are you going to be on vacation for 2 months? Or are you totally backed up on other cases? Are you taking on too many cases? And to make certain that this thing moves along, that comment that we made last week, that everybody remember, that insurance company customer is every bit the customer to the insurance company, despite the fact there's a difference of opinion regarding the amount of the loss than they were before the loss ever happened. And we think the insurance company owes a good faith duty to select appraisers that are going to be able to quickly and efficiently go through the appraisal of the case. Similarly, policyholders also ought to be asking the same question. I've thrown up my arms and yelling at some, will you get your work done on our side? So for all I know, that goes on the insurance company side too. I really don't know. I'm not there, but I do get upset when it's just taking too long either way. So sometimes when we're appointing the umpire, I've asked judges to set a time frame for when it is, to have them reporting back to the court once a month, and let the court know if this is taking more than 60 days to get done. They have a order to show cause why it's taking for more than 60 days. I think, at that time we can ask for the court to move things along. And a lot of people think 60 days. Well, it's the way it was. Appraisals used to go a lot faster than what a lot of them are going today, because of the demands for many appraisals and appraisers and umpires. It's just is being used a lot more, but it's supposed to be a fast and efficient process. It does not supposed to be taking an inordinate amount of time to get done. So, for everybody who's doing this, I would suggest you got to ask yourself, do I have enough time to get these cases pushed through, or do you need to tell the person that's hiring you, maybe you need to go hire somebody else?
Yeah, and don't forget about jurisdictions that allow a contract to limit the statutory period of time to file a lawsuit. Because a lot of times we get phone calls and it's too late because the appraisal process is taking too long. The insurance company may, at that point in time, contest coverage on supplemental items, and it creates a real big problem for the policyholder because their claim is time barred. And so a lot of jurisdictions, the contract is not allowed to limit the statutory period to file a lawsuit. But in a lot of other jurisdictions like Oklahoma and Colorado and Texas and different places, you have 1-2 years from either the date of the occurrence or date of loss to file a lawsuit. And if you're involved in a supplemental claim and the appraisal process is taking that long, I mean, Illinois, you can reduce a policy to as short as a year.
I think in some where you have to watch out, and this is the gotcha part of it, you go through an appraisal, most people just assume that the statute of limitations is told, and then you find out it's not. Of course, I think it should be, but that's not me. It's some courts take a look at it and say, no, you have 2 years, that's the end of it. It doesn't say anything in there, and there's no either statutory or common law tolling, and you go back to enforce it, and they say it's too late, even though you got an appraisal award. To me, it sounds crazy to do, but that's because
some states do. Like, for example, in Illinois, if you file a proof of loss it tolls that time period. So talk to the lawyers in that jurisdiction that practice there and make sure you're aware of what happens if the carrier doesn't pay the award. What should we do? Typically, they'll agree to a towing agreement or something else to prevent litigation.
But you need to know that up front.
Yeah,
Right.
absolutely.
So
All right.
let's keep moving along here. How we doing?
We're doing great. We got two more questions on the PowerPoint, but we can also take more questions. So we've been answering questions here online. Jeremy makes a great point. He says, look, I have seen some policies that do require site inspections. He says about 2 or 3% of them.
So read the policy.
Yeah. So, I mean, obviously, Jeremy, you're right. If the policy requires it, you have to do it. Let's see here. One of the questions we had that's not in PowerPoint is what happens if you have a standard fire policy and there's a certain appraiser provision in the standard fire policy, right? And I think we talked to Ed Issue right before this presentation.
Ed Issue is the golden guru with respect to the standard fire insurance policy. Ed's out of a Chicago office where they have standard fire insurance policies in Illinois.
Yep. And so we asked him about this question of, well, what appraisal provision would dictate what applies? And he kind of gave some examples about, well, you know, if first of all,
First of all, the question is, in most states, for the standard fire insurance policy to apply, it's got to be a fire. So you got to figure that out first. Are you in a state with a standard fire insurance policy that's required? If it is, in that state, does it only apply to fire losses or does it apply to other losses? The general rule, like it is for most things in their standard fire policy, whatever is, you can say most restrictive, these are minimum standards with respect to what have to be offered the policy to insured, so that if for some reason the appraisal clause in the new one might come out and say you can't determine causation, but under the standard fire policy and the case law in that particular state would say that the appraisal panel can determine causation, then causation can be determined. That's just the way it would work. If the days are different, whichever one might be longer for the policyholder, maybe to appoint somebody or whatever it might be, but it's
whatever benefits the policyholder.
Benefits the policyholder, because these are minimum safeguards for policyholders that all insurance companies, you know, have to adhere to.
Yep. All right, that's a good question. Here's what if you find out that an umpire and an appraiser have done several appraisals together and have ruled favorably for one another after you have verbally agreed to that potential umpire? Well, the first thing you did is you watched our presentation last week, and you know not to agree to an umpire until you get disclosures. Ed Facco makes a great point in the comments here that some jurisdictions like California require full disclosure of the panel, right, as an affirmative action. So in California, there is no request that has to be made to comply with the statutes in California. They actually have to proactively provide these disclosures. In Colorado, there's a set of disclosures you have to comply with, and it kind of varies by jurisdiction. But before you do anything or agree to an umpire, you're going to take those questions that we provided and ask those questions of the umpire before you make your decision to avoid that beforehand. And if you find out beforehand, you know not to agree to them if you feel like there's a problem, or you can ask some follow-up questions that may comfort your concerns and then agree to them. But if you are in a situation that this person's worked with this umpire in the past and you didn't know about it, too bad. It doesn't matter. I mean, if there's no disclosure requirement or they don't misrepresent anything to you, the umpire is allowed to work just like your umpires, guys. I mean, appraisers all have umpires they work well with or they feel are fair. Doesn't mean I'm going to try to game the system to get my result. It's because you believe in your result and you want a fair umpire. If you have the same umpire on multiple claims, that doesn't mean that you're doing anything wrong, and it doesn't mean the umpire is doing anything wrong. It's just the reality is, God, people are lazy. And when you find good people, you end up getting a lot of the same type of work. And it's hard explaining to courts.
Or somebody has a lot of credibility as an umpire, and both sides say this person has a lot of credibility. Typically, then both appraisers at one time or another worked for this umpire and with that umpire in the past, finding that perfect umpire, because there's not a lot of people that sometimes get viewed that way. Umpires sometimes get pigeonholed into being people that just split the differences no matter what's put out there. They don't work, both appraisers very hard. They don't ask the hard questions or are afraid to push matters along, whatever it might be, and to find really good umpires to do things in such ways to get the panel moving, to come up to an honest result no matter what side it favors. Those people will tend to, I would think, get selected much more often because they're actually to the benefit of both sides.
Yeah. So I'm gonna keep doing some questions here live, guys. So keep them coming in because we got some time. I do like this.
You like that?
It's more involvement. It's more
But we're
fun.
going to stop because it's Cinco de Mayo. And it's not that long. You know, it's going to be 3 o'clock Eastern Standard Time. And a lot of my friends are going to say, you know where lawyers end up going on Cinco de Mayo during coronavirus. Now we go back home. That's where we go.
Yep.
We're now going to be making margaritas at our house. A little bit different this year.
I've got tacos waiting on me. So Wesley Barber asked the question, when calling in a claim, do you use the data discovery or data loss? He has an example of weather data supports hail from 2 years ago but discovered recently. It's the data loss, guys. It's the data loss. And the policy says it's that policy period. Now there's statute of limitations that are different from the data denial. There's an argument in some jurisdictions that the statute of limitations doesn't apply until there's a date of denial. There's also tolling issues I don't want to get into, but generally speaking, if you have to have a storm date that triggers a policy period. So Wesley, if I take your question, I say, okay, I discover the storm, and I go from Hartford to Chubb in 2017 to 2018, and you discover this in 2018, you can't use the date of discovery because this is an occurrence-based policy. It's not a claims-made policy.
Yeah, there was some, I saw, you know, there's so many new attorneys doing this. Somebody wrote down, I thought it was the date you went and discovered. It's like some trigger, you know, type thing, like a liability policy or a claims-made policies. No, guys, you go back to the actual date of the loss and what was the policy. As a matter of fact, typically the things you have to prove is that there was a loss that occurred during the
Policy period.
bingo.
And really where this comes in is when people use companies like Hail Trace and CoreLogic and they know there's hail damage and they're trying to figure out what storm caused that damage.
And the big thing in Texas, Oklahoma, Colorado, and some of the other places where they have hail right now that is a recurring hail damage to many places is like, well, which loss is it? And the insurance companies are all searching, well, we think this hail is 5 years old, 7 years old, 11 years old, not the year that you're claiming this hail damage happened years old. And so that tends to be where a lot of the disputes have started to arise in those, and it's a big issue. You have to prove for the hail damage that you're looking for that it occurred in that policy period. There have been some cases that we've been following that luckily we didn't have, but some other people have, that they've learned that lesson, unfortunately, and the insurance companies won on summary judgment because they didn't go out and have sufficient evidence to prove when that happened. This is coming up quite a bit, though, especially on the hail damage claims where they're having recurrent hailstorms and trying to prove what this old hail looks versus the newer hail looks.
Right? Yeah, and the more you take it extreme, the more it gets reeled back in. I mean, in Dallas-Fort Worth, for example, you have storms every year, and in these areas. And I've seen where policyholder attorneys or public adjusters will take these claims and they'll try to make them fit a puzzle. And then, of course, it creates bad facts, which creates bad law. And now Texas law has risen the bar. Risen the bar. I don't think they raised.
You know what a raisin?
I said raised.
Raisins are what you find out from grapes when they get old.
Go get your margarita. All right. But here's the point. The point is that bad facts lead to bad law. And now what you're seeing in Texas is that they've raised the bar for coverage. And the fact that you have to actually prove the specific storm date caused that specific damage instead of what we all kind of know, which was they have to prove an exclusion applies. So we have one more. Do you need one more question to be finished?
Well, it depends on how good the questions are. We have 10 minutes to go. I guess we're going to go 1 hour.
Hey,
but if we finish early, you know what that means.
Oh,
Party gets to start a little bit earlier.
for
So
the record,
let's go.
I was going to be fired if I didn't wear this hat. All right, so
You're
Gary.
just jealous because you don't have as dark a mustache as I
That
do.
is true. So Gary Gillette actually has a great question because we kind of take it for granted. And it says, what is the process to request the court to appoint an umpire? Does it have to be via an attorney, or can we provide a list of potential candidates?
For what?
So let's say they can't agree on an umpire, and then you have to go to court for an umpire. What's the process?
I'll tell you a funny story. It's a true story. I won't say the names to protect the guilty on this, but I get a phone call from an attorney who is an insurance defense attorney. And he says, Chip, do you know this particular adjuster, public adjuster? I say, yes, I do. He goes, I think he needs some help because the judge is about to throw him in jail or hold him in contempt. I said, what for? He says, well, he filed a petition on behalf of the policyholder and is arguing in front of the judge who the umpire ought to be. And I mean, guys, that's the practice of law.
That's what I went to law school for. I spent a lot of money to do that.
Right, and you can't do that. And the judge, I was reading the transcript on this, and it got to be serious. I helped out and helped get everything taken care of afterwards for this, but and I will say that the attorney who's watching this, he probably knows who he is. The public adjuster who probably should be watching this is not watching this, I'll bet, but he's pretty notorious at times, and so I think it was a lesson that was learned, and this goes back 20 years ago, I would say, but the only people that should be saying and presenting anything to judges in court are lawyers. I guess a person can represent themselves.
That's the workaround.
If they want to be, that's the work. But that doesn't mean the public adjuster should be telling them what to do.
Right.
That would be wrong too. And I seen that. We'll write up the complaint for you. We'll put it in. We'll just let you go file it.
Right.
And we'll do all kinds of things for you. You'll go do it. We know what to do. We've seen other attorneys do it. You can't do that.
So practically speaking, the process is, the client would hire the attorney. Typically, it should be on an hourly basis. Don't have a contingency fee for compelling an appraiser, for crying out loud. If it's a homeowner,
If that's all it is.
I mean, give me a break. If you got to fight over other issues,
Well,
that's different. But if it's just pointing an umpire, typically you get an attorney to do it for an hourly wage, to get to the court, file a motion, and literally what you do is you take 3, 5, 7 names, whatever you want to put in there. You put the CVs behind them, and then you file a petition to compel the appraisal or appoint an umpire, depending on what the issues are. And then when they appoint the umpire, they're going to pick off your list. Oftentimes there's a hearing. They hear from both sides, and the court just picks one. And that's why it's always best if you can agree, because you don't know what you're going to get from the court. It's also why we like retired judges, because judges have a impartiality and a fairness, quill over them that kind of gives us a blessing to get them on the case instead of maybe a JSL representative or somebody with a relationship with the carrier that you want to try to avoid.
Yeah, don't get me wrong. There was I need to call a policyholder after this is over because she watched last week's segment and liked it enough. She contacted me and I owe her a phone call back just to give her a name of an attorney, but she had indicated to me that she had actually selected that the appraiser actually works as an insurance company lawyer. She went down she didn't look at the phone book, she looked at Google and picked out somebody who was good as an appraiser who does insurance law, and she thought this person would be great. That person represents insurance companies, and you can guess how come she's now looking for another attorney to try to get her out of all those situations. So yeah, it's it just never seems to stop on some of that. But whatever the questions we have.
I think that's it. I think that's all.
Megan, are there any more questions that have come through that you've got?
Yes. I think Doug just asked a very good question.
Oh, who asked another
Oh,
question?
I got it right here.
Okay.
So what's the question?
So Doug, and I think I don't know if the silent is K or not, but come on, man. I'm still appraising Irma losses down in Naples.
So a lot of people are. As a matter of fact, there seems to be a whole bunch of them coming up on Irma. Irma's
good. That's the question. We're all finished.
Irma's the never-ending hurricane, but let's keep going.
The damage observed and documented in September or October 2017 looks different than what I am seeing or looking at the loss in 2020. The insured hasn't had the economic resources to get the roof replaced, and multiple repairs and or tarps have failed over the last 2 years. Do I do my evaluation based on what I'm seeing today versus what was observed in 2017?
The typical rule for this, and it can be argued both ways because it is a replacement cost policy, but the typical rule is you determine what the damages are at the time of the loss. And it's typically because the courts are looking for something that would be definitive at that time. As a matter of fact, like for the delay reporting and things like that, I'd be concerned about the insurance company claiming prejudice depending upon what's happened. If it harms the insurance company because there's a late notice of loss and the cost of all of a sudden gone up more, like if you had a loss of Hurricane Irma and you just made the notice you put the notice of loss in today and you're trying to claim today's dollar amounts for construction that might be going through the roof because contractors are either more difficult to go get or because of everything they're having to do as a result of the coronavirus, you might find yourself in a prejudice situation. So
let's assume the claim was reported.
And most states, and there's some arguments back and forth on the replacement cost policy, but it's usually at the time of the loss.
I think the way that I would handle that situation is I would determine when the claim was reported, because if it was reported in 2017 and this is a supplemental claim, I'd make sure that the policyholder submits those supplements, kind of like what we talked about earlier, to determine what should be considered. Because at the end of the day, if the carrier came out and said it's below deductible, I believe they're on the hook for that entire loss if it's covered. I mean, if there's a covered event from Irma and they owe for the roof replacement, and the carrier's investigation led to additional damages or to consequence of the loss, I think appraisal may not even be your best avenue for resolution. You may actually need to be involved in litigation at that point. But the point is, get the claim reported, make sure the damages are being claimed, and then determine from the opposing appraiser what's going to be in the appraisal. I recommend you include, if you want to, at minimum, both of them. And then if the carrier wants to exclaim coverage, then you can litigate that issue after the fact. But that kind of defeats the whole darn purpose of appraisal, because your goal is to resolve the claim. So see if you can get that reported and include that within your assessment, because obviously the insured is owed to be made whole. And if the carrier's conduct led to that problem, then I don't think it's the insured's problem.
Yeah, you know, there's another, I've done it both ways to show, because the insurance company denied the claim, this is what the loss would have been at this particular date. Because the insurance company dragging out
It's your bad faith.
the adjustment and all that, this is what it's going to cost by the time the payment is going to be made, and this is what, you know, the cost is going to be, you know, for the bad faith damages or the consequential damages for the insurance company not adjusting the claim you know, properly or promptly to begin with. So you do have some other arguments depending upon how you do this, but those are typically in a court of law. I guess there's no rules in appraisal again. I keep saying that, but
Right.
the typical rule is it's at the date of the loss. That's the majority rule throughout the United States.
I think we got time for one more.
One more,
Okay, here
and then
go.
we get to go. Should I do it one last time?
Oh, boy.
Here we go.
All right. This is a good one. Can an appraiser or umpire demand paid invoices to determine a settlement?
Can they what?
Demand paid invoices to determine a settlement.
Sure, they could ask for paid
Of
invoices.
course they can ask for paid
They could ask for anything they want to.
Right, because here's what, loss settlement provision. Here's something that a lot of people confuse. Insurance companies don't owe for an estimate, guys. They don't owe for it on a replacement cost basis. They pay for an actual cash value amount, replacement cost basis, they owe for what was reasonably and necessarily incurred by the insured. That could be more than their estimate, it could be less than their estimate, period. So if the umpire, if the roof is built and they want to know how much it costs to build the roof to determine what the replacement cost is, of course they can request that information.
It might be, what you actually paid might be proof that the estimate's too low.
Right.
It might be proof that you just paid for something that you paid too much for.
Right.
It should have cost you $50,000 and you went down to, and you paid $100,000, you dummy. Or the $100,000 that should have cost, that the insurance company had estimated 50, it really is $100,000. You know, on the other hand, it could be, you have estimates but what did you really get it done for? Because the policy you only pay up to the most replacement cost policies. Not all will only pay up to the amount that you actually expend. You have some, what I call true replacement cost policies that will pay the full amount for the replacement the way it
Great
is.
value. Right.
But you would still be able to ask for actually what the invoices would be.
Yeah.
If there's work that's been done on it and that's the information's out there, both sides should be able to
But
go
here's
get
the
that.
exception. Here's the exception. Not for subcontractors. It's what's billed to the consumer. Okay, so often what I'm seeing is they want to know what Starbucks bought the coffee for. That's ridiculous. You don't get to know what your roofer got the tiles for or what they're paying for their labor. So to be clear, we're talking about what was billed. The invoice is billed to the consumer, not to the subcontractors. Thank you very much. Go get a margarita. Sorry for the hat. Next week.
Happy Cinco de Mayo!